For months now, a single question has been circulating across headlines, comment sections, and gun law discussions nationwide. Has the Supreme Court already ruled on AR-15 bans? And if not, why does it feel like the decision is always right around the corner? The confusion is understandable. Lower courts have issued rulings, states have enforced bans, news articles have used vague language, and many people have come away with the impression that the Supreme Court has already made up its mind. But here's the reality. The Supreme Court has not issued a final ruling on AR-15 bans, and there will not be a definitive ruling next week either. That fact alone raises an even bigger question. If the court hasn't ruled, and if these bans are being challenged nationwide, why hasn't the Supreme Court stepped in yet? To understand what's happening, it's important to understand how Supreme Court cases actually move, why delays are often strategic, and what it really means when the court chooses not to act. Right now, AR-15 bans exist in several states, including California, Illinois, New York, and a handful of others. These bans are being enforced under state law, but they are not the result of a nationwide Supreme Court decision. They exist because lower federal courts have either upheld them or allowed them to remain in place while litigation continues. That distinction matters more than most people realize. When a federal appeals court upholds a law, that ruling only applies within that circuit. It does not become national law. It does not bind other circuits, and it does not represent the Supreme Court's view on the constitutionality of the issue. Yet headlines often blur that line. When people hear that a court upheld an AR-15 ban, many assume the Supreme Court has already spoken. In reality, what's happening is a patchwork of conflicting rulings across different jurisdictions. Some courts have ruled that AR-15 bans are constitutional. Others have ruled that similar bans violate the Second Amendment. Still others have avoided making a final decision by sending cases back to lower courts for additional review under the Supreme Court's Bruin framework. This is what legal scholars call a circuit split, and historically, it is one of the strongest signals that the Supreme Court will eventually step in. But eventually is the key word. The Supreme Court does not operate on public urgency. It does not rule based on trending topics or media pressure, and it almost never resolves major constitutional questions on short timelines. In order for the court to issue a ruling on AR-15 bans, several things must happen first. A case must be fully litigated in the lower courts. A final judgment must be entered. A petition for certiorari must be filed. The court must decide whether to take the case. If it does, briefing and oral arguments must follow. Only after that process concludes does the court issue an opinion. That process takes months and often years. So when people ask whether the Supreme Court will rule on AR-15 bans next week, the honest answer is no. There is no case currently scheduled for argument on that issue. There is no opinion pending. There is no legal mechanism for a sudden surprise ruling to appear out of nowhere. What can happen, and what sometimes causes confusion, is procedural action. The Supreme Court occasionally rules on emergency motions. These can include requests to block enforcement of a law while a case is pending, or requests to allow a lower court ruling to remain in place temporarily. When the court denies one of these requests, the lower court ruling stays in effect. But that is not a ruling on the merits. When the Supreme Court declines to intervene at an early stage, it is not saying the law is constitutional. It is saying the case is not yet in a posture that warrants Supreme Court review. That distinction is subtle but critical. In recent years, the Supreme Court has made it clear that Second Amendment cases must be evaluated using a specific framework. In the Bruin decision, the court rejected interest-balancing tests and held that gun laws must be consistent with the nation's historical tradition of firearm regulation. That ruling reshaped Second Amendment litigation overnight. But it also created uncertainty. Lower courts have struggled to apply the Bruin standard consistently. Some have taken it seriously, striking down gun laws that lack historical analogs. Others have interpreted it narrowly, upholding modern regulations by stretching historical comparisons. This inconsistency is part of why AR-15 ban cases are still moving slowly. The Supreme Court often waits for lower courts to fully work through new legal standards before stepping in. This allows the justices to see how the rule functions in practice, where disagreements arise, and which legal arguments are most developed. In other words, delay is not inaction, it's observation. From the court's perspective, AR-15 bans represent one of the most consequential Second Amendment questions since Bruin. A premature ruling could create unintended consequences. A poorly framed case could limit the court's ability to address the issue comprehensively. So instead of rushing, the court appears to be waiting for the right vehicle. That does not mean the court is avoiding the issue forever. It means the court is choosing its moment carefully. Another factor at play is the concept of common use, which has become central to AR-15 litigation. The Supreme Court has repeatedly stated that firearms in common use for lawful purposes are protected by the Second Amendment. Lower courts disagree on how to apply that principle to AR-15s. Some argue that their military lineage places them outside constitutional protection. Others point to widespread civilian ownership as evidence that they fall squarely within the scope of the Second Amendment. The Supreme Court has not yet resolved that disagreement. Until it does, lower courts will continue issuing conflicting rulings, and states will continue enforcing bans within their own jurisdictions. That leads to another common misconception. When people say AR-15s are banned, what they often mean is that they are banned in certain states under state law based on lower court rulings that may not survive Supreme Court review. This is not unusual in constitutional law. Before major Supreme Court rulings, it is common for rights to be recognized in some jurisdictions and denied in others. The Supreme Court often allows this inconsistency to persist until it is ready to issue a definitive nationwide ruling. We've seen this pattern before in cases involving free speech, abortion, marriage, and other constitutional rights. Gun law is no different. So what happens next? In the near term, AR-15 ban cases will continue moving through the appellate courts. Some will be upheld, some will be struck down, some will be remanded for further review under Bruin. Eventually, one or more of these cases will reach a point where Supreme Court review becomes unavoidable. At that point, the court will decide whether to grant certiorari. If it does, the case will be argued during a future term. Not next week, not next month, but likely well into the future. Until then, the legal landscape will remain fragmented. This uncertainty fuels speculation, and speculation fuels engagement. That's why this topic continues to trend even without a final ruling. People want clarity, they want certainty, and right now, neither exists. That makes this moment uniquely important. The absence of a ruling does not mean nothing is happening. It means the legal groundwork is being laid. Every lower court opinion adds to the record. Every dissent highlights unresolved questions. Every remand clarifies how the Bruin standard is being interpreted. When the Supreme Court finally does act, it will do so with a full view of the battlefield. That's why expecting a ruling next week misunderstands how the court operates. Supreme Court decisions are not spontaneous. They are deliberate, procedural, and slow by design. So if you're wondering whether posting about this next week will be outdated, the answer is no. The absence of a ruling is the story. The fact that AR-15 bans remain unresolved at the highest level is precisely why this issue continues to matter. As long as the Supreme Court has not ruled, the legal status of these bans remains unsettled. As long as lower courts disagree, the court's eventual intervention becomes more likely. And as long as people remain confused about what has and has not been decided, there is room for clear, accurate explanation. That's where this discussion belongs. Not in panic, not in premature conclusions, but in understanding what the court has actually done, what it has not done, and why timing matters. The Supreme Court has not ruled on AR-15 bans. It will not rule next week, and when it does rule, the decision will reshape gun law nationwide. Until then, the waiting is not a sign of weakness or avoidance. It is part of the process. And understanding that process is the difference between reacting to headlines and understanding the law.